Hi everyone, and welcome to another episode of Legal Tings. Today we're talking about how you use a mitigation plea to plead for leniency in your criminal case. When will you present a mitigation plea in your criminal court proceedings? After you've either pleaded guilty to a charge or you've been convicted after a trial, the court will give you or your lawyer an opportunity to present your mitigating factors in support of your arguments for a lighter punishment. A mitigation plea can be presented orally just by speaking to the judge in court or by presenting it in a written document. Either way, it needs to be done in a clear, organized, and systematic manner, and together with supporting information or evidence wherever it's necessary or relevant. If you're unable to speak in English and need to present your mitigation in another language, you can let the court know in advance, and an interpreter will be provided to help you translate what you say. Your mitigation plea should contain the mitigating factors for the court to consider in deciding on the most appropriate and suitable sentence and punishment for you. Mitigating factors are typically the facts and circumstances of your case which help to reduce the wrongfulness of your actions and your involvement in the offence. Some common mitigating factors include your remorse in pleading guilty and wanting to take responsibility for your actions, your young age when the crime was committed. If you are a young offender or someone who is below 21, the court may be more sympathetic and consider choosing a type of punishment which focuses more on your rehabilitation, such as probation. Facts showing that you had a smaller part or involvement in the commission of the offence, such as if you played a minor role in how the crime was carried out, if you carried out the crime impulsively and without premeditation, if no amount or only a small amount of hurt, injury or loss was caused to someone else, or the fact that you've made restitution to the victim, meaning you've repaid either some or all of the money that was taken from him or that he lost, or whether you have a strong potential for being reformed and not committing other offences in the future. You could also mention your commission of the offence being out of character and that you previously had a very good track record in terms of your behaviour and conduct in your personal and professional life, or that your involvement in the offence was caused or contributed to by an underlying psychiatric illness. Ultimately, how much weight the court will place exactly on these mitigating factors will depend on the unique facts of every case. You should also remember that not all examples of your good behaviour and conduct will be regarded as mitigating factors that are capable of justifying a lighter sentence from a legal perspective. For example, the financial hardship that your family will suffer because of your punishment or imprisonment will generally carry little weight as a mitigating factor. Similarly, your high level of education or outstanding professional achievements will also not automatically be counted as mitigating factors, although they may help to show the court that there's a strong likelihood that you'll be able to turn over a new leaf and ensure that you don't commit other crimes in the future. What then happens after you presented your mitigation plea? After you presented your mitigation, the court will then decide on the appropriate sentence to impose on you. When the sentence is imposed, it will generally take immediate effect from that day onwards itself. This means that you'll need to pay the fine in full or start serving your term of imprisonment immediately, unless the court has agreed to give you more time to either make the payment or start the imprisonment on a later date. If you've asked to defer or delay the start of your imprisonment, the court can demand additional terms and conditions to be imposed and fulfilled to ensure that you surrender yourself on the deferred start date and you don't instead abscond or run away before serving your sentence. For example, you may need to surrender your passport or travel documents, or your bailer may need to provide additional or increased bail. So, do you need a lawyer to prepare your mitigation plea? Well, a mitigation plea doesn't necessarily need to be prepared or presented by a lawyer, but it's probably a good idea to at least speak to a criminal lawyer in advance to understand what exactly is relevant from a legal perspective and worth highlighting in your mitigation, and what factors are actually not likely to be given much weight by the court. More importantly, a criminal lawyer can also help you by obtaining information and details about previous cases that you can then use to compare and show how your own case is not as serious as other cases and that you then deserve a lower sentence compared to those cases. So, now you know. If you enjoyed listening to this and would like to hear more, subscribe wherever you like to listen to podcasts and follow me on TikTok and Instagram. And remember, it's not rocket science. It's just legal things.